Everything we do involves contracts, contractual provisions, and intellectual property rights and intellectual or IP property decisions. Here's what you need to know. Today, I'll be discussing with you 13 different contracts or agreements you may want to think about including in your practice, if you're not already doing so, and 5 of my favorite business/legal provisions that will keep you safe and keep your clients or customers safe. So grab a pen and paper and take notes. Let's get started. My name's Mitch Jackson. I've been practicing litigation and trial law here in Southern California for the last 35 years. Many of you know me as someone that loves helping out online entrepreneurs, social media agencies, brands, influencers, and brand ambassadors with their business and legal needs. That's why I'm here today, and hopefully we'll get you going in the right direction when it comes to doing business in today's crazy and sometimes upside down, complicated world. Now, before I dive too deep into today's presentation, intellectual property rights, IP rights in today's world, this is where I see a lot of people making a lot of mistakes with respect to protecting their IP rights and properly using the intellectual property of third parties. For this reason, I brought in 3 experts, 3 friends of mine who are gifted and talented intellectual property attorneys to help shine a light for you on this particular issue. And one more thing. No legal advice is being given. While I am a pretty darn good California trial lawyer, I'm not your lawyer. No legal advice is being shared today. What I am doing is offering suggestions, planting seeds, getting you to think a little bit about some of the different contracts, contractual terms, intellectual property rights that will come into play for most business owners. So if you have any questions, reach out to a qualified lawyer in your state, in your country, to get those questions answered. All right, let's dive in. 12 contracts, 12 different types of agreements that I think you probably should be using, but most of you aren't. Number 1, a production or work agreement. This is the master agreement that you absolutely want to enter into with a new client or with an existing client if you're expanding the scope of the services that you're providing. This master agreement delineates in writing and is signed and dated by all parties to the agreement who have authority to enter into the agreement. Key point there, make sure you get the right people signing the documents that you think everyone's entering into, but it lays out exactly the scope of work. What will you be doing over what period of time? What's the rate of pay? All of the different terms and conditions that are part of your work agreement with a client need to be included in a master document, okay? We use DocuSign to easily circulate and date and sign these types of documents, but I see a lot of business owners, a lot of agencies, a lot of brands, a lot of brand ambassadors and influencers fail to document in writing what the underlying agreement is. So make sure you have and are using a production or work agreement. Now, with respect to these agreements, we're going to dive into the specific clauses, some of my favorite clauses that should not only be in your work agreement, but probably some of the other agreements we'll be talking about. So stay tuned, because towards the end of this video, I'll be going through my 5 favorite clauses that I believe should probably be included in most of these types of agreements. So number 1, a master production agreement. The second document is called a location release. When you're out and about, when you're on private property, when you're out in public creating content, do you have permission from the owner or the person that has license rights to the property that you're on to be using that property to create your content? Give this some thought. Make sure you have legal permission to be located physically on the premises where you're creating your content. The third agreement is what I call an intellectual property or IP agreement. Now, this agreement can be a separate agreement or it can be part of your master agreement that I referenced in number 1. In fact, all of these different agreements can be incorporated into one agreement, or you can break them down into separate agreements. But it's critically important that when it comes to intellectual property rights, you have something in writing that specifies who owns those rights, who gets to use the intellectual property, and everything else in between. Why is this so important? Because if somebody comes to you and says, it's okay to use this logo. It's okay to use this video or photo. Maybe it's a client. Maybe it's an independent contractor that you've contracted with to help you create your content. And if that third party doesn't have the legal right to tell you it's okay to use somebody else's intellectual property, that can cause some serious financial problems, some serious legal liabilities for you and your company. But don't take my word for it. My dear friend Pete Salsich III, who's a talented IP lawyer and chair of the Entertainment and Media Practice Group at Capes Sokol, explains the details. I asked Pete the following question: what legal proceedings, equitable relief, and damages should a creator, an agency, the owner of IP, the user of intellectual property, be concerned with when it comes to the violation of an IP right, such as a copyright? What happens when there's a claim or litigation?
Great question, Mitch. There's several different proceedings that can happen. So the first is you could be hit almost immediately with a temporary restraining order. So the copyright owner can go into court and get it without notifying you if it's really an emergency, and get a court to order whatever it is that you're producing, whether you have content on the air or a television show on the air or a movie in the theater, whatever it might be, or getting ready to go, for example. And the court can order that to be restrained, to be shut down, not shown for a brief period of time, typically 7 to 10 days, enough time to get notice to their attorneys. And then you're right back in court for a preliminary injunction hearing, which can happen very quickly. And in that setting, you may have to do discovery. You may have to submit the depositions. You may have to produce all kinds of documentation about how you chose the material. Did you search? Did you do any investigation to see if somebody else owned a copyright, for example, if you're using some other third-party materials that you didn't have a right to? And you're going to have to do all of that in a matter of days or a week or so. And one thing that lawyers will tell you, that litigation is expensive, but fast litigation is really expensive. And yet that's what you have to do. You'd have to immediately show up in court to be able to prove that you are not guilty of infringement. And if the plaintiff, if the copyright owner is able to convince the judge that it has a likelihood of succeeding on the merits. Again, it's not proving the case all the way to the end. It's not a jury decision. It's simply proving that they're likely to proceed. They've got enough evidence to go forward. Then the court can enter a preliminary injunction, which will last all the way to the end of trial, which might be a year later. So those are the things that are most immediately, and they will get your material taken down while the court moves through its normal, slow plotting process to determine ultimately who's right or wrong. But if you're a creator and and your whole business depends on getting the work out there, if it's taken down even for a day, that might be devastating. But taken down for potentially 6, 12, 18 months probably simply ruins everything. And if part of your business is that you've promised somebody else that the materials you produce they can use, you're going to be in breach of your contracts as well. So that's the first two pieces that come up, Mitch. And then the third is if the case goes all the way through into past the preliminary injunction stage, then there's damages. And those damages can be calculated really one of two ways. It's either what the copyright owner, the plaintiff, lost because of your use, and that might be a royalty, that might be a license fee. In other words, they may normally license this type of material, and so they lost the revenue because you just took it. And not only will they be able to get their normal license fee, but because you didn't ask, they're likely to be able to get more, maybe double that license fee, for example. The other thing that they can do, and this is particularly troublesome if your content has actually generated profits for you or anybody else, profits in the hands of the studio that you sold it to, profits in the hands of the network or the brand that hired you. The copyright owner can attack everybody's profits that result from the use of their work. Now, there's a question of, did the profits come from the work? Did the profits come from other materials? Things like that. But the fact is, all the plaintiff has to do is prove your top line revenue. Then you have to prove that you only got a tiny little bit of profit from their work. In other words, you can be exposed to getting your material taken down almost instantly, paying attorneys a great deal of money quickly, and frankly, also completely disrupting your normal business because you have to cooperate with your attorneys to get them all the information they need. And then on top of that, you may have to continue to pay attorney's fees and pay damages, possibly even the plaintiff's own attorney's fees. So it can literally destroy the business or the property in some cases.
I think we can all agree that appreciating the implications of intellectual property rights, getting permission to use the IP of someone else, it's critically important for the long-term success of not only what you're doing for your client, but your business too. If you guys have any questions, reach out to Pete. He's one of my go-to IP professionals. The next document I'd like to talk about is document number 4, talent releases. Are you using properly created, drafted, and signed and dated talent releases with people who you're using in your content? Whether it's a podcast, whether it's a video, whether it's a blog post. If you're interviewing somebody, if you've got professional actors that are engaged in your content creation, are you using talent releases, not only to protect you, but to also protect your clients? The 5th agreement, the 5th document you want to take into consideration are what I call video, podcast, and other content creation proposals and agreements. What I mean by this is you may have a project that was brought to you that you're working on for a client. And within that project, there may be podcasts, videos, clubhouse rooms, TikToks, Instagram, reels that you're preparing. Depending on the talent that you're using, the people or third-party companies that you're using to help prepare and create this content on your behalf, you may want to be entering into separate, short one-page agreements with each of the respective content creators for each of these different platforms. Each platform has a different TOS, a terms of service agreement. Each platform has different requirements, different legal implications and ramifications, depending on what you're doing for your client, depending on what state you're in, what country you're in, and what regulations control what you can or can't do or say regarding certain products and services. If you're helping out my law firm as a lawyer, there are certain things that we can and can't put out on social media that maybe the local tire store down the street can. So you want to make sure that as you're using all of these different media creation venues, you're using appropriate agreements to protect yourself as to the use of each of these different platforms. And once again, I simply call these video, podcast, or content creation platform sub-agreements. You can incorporate this into the master agreement if you planned ahead. Otherwise, as you continue to work on a particular project and you decide, you know what, we're going to complement this Instagram story with a TikTok video, make sure that if you're farming out the creation of these 2 items, that you have documentation delineating exactly who's doing what and including the terms that I'll get to towards the end of this presentation. Okay, agreement number 6, statement of work agreements. And what these are simply an itemization, a detailed list of what it is you are doing specifically for a client. Oftentimes, this is incorporated into the first master agreement, but once again, as new platforms roll out, as things change, as you're looking at the results of what you're creating for your clients, and you decide you want to pivot and maybe take that message to a different platform, you want to make sure that you document any of these changes, any of the things that you're promising your client, and frankly, what your client's expecting from you, what they've asked you to do, you want to document in writing. So I call these statement of work agreements. Oftentimes we'll incorporate this as an attachment to the first agreement we talked about as an addendum, and it's an addendum that can be updated and modified at any time, so long as all parties agree to it in writing and sign and date that modification or update. Okay, once again, we're going through different agreements and contracts that you may want to use in your everyday work. Number 1, production agreements. Number 2, location releases. Number 3, intellectual property related agreements. Number 4, talent releases. Number 5, video, podcasts, and other content creation sub-agreements. Number 6, a statement of work agreement. What exactly are you doing? And once again, this is oftentimes incorporated into the first agreement. Number 7, this is an area I see a lot of social media agencies, creators, and people who own or think they own intellectual property rights get tripped up on. And what I'm talking about are work for hire agreements. Now, you can Google any of the terms that you hear me mention if you're not familiar with the legal terminology. But generally speaking, a work for hire agreement is an agreement that says if you're employed by someone else and during that employment you create something that would normally be your intellectual property. Well, a work for hire agreement says, thank you, we're paying you as an employee to create this content, but it belongs to the company. It belongs to the agency that's hiring you to create this content. So if you're an agency, you want to use work for hire agreements and you want to deal at arm's length, you want to be transparent. But when you bring people in, you want them to know that the content they're creating, whether it's podcast, video, logos, whatever it might be, belongs to you because of the work for hire agreement. A lot of agencies aren't using these agreements, and you probably should. Protecting your intellectual property rights, protecting your copyright is critically important. It's so important that I've asked my friend Karima Gulick, who's an IP lawyer here in Southern California, but not just an IP lawyer. She's an aeronautical engineer, she's a private pilot, and she's one of the most talented lawyers I've had the pleasure of meeting in a very long time. And I reached out to Karima and I asked the question, Karima, what steps should an agency or creator take to protect their intellectual property rights, such as copyright? Here's what Karima shared with me.
Hi, Mitch. That's a really great question and something that I see entrepreneurs and new businesses do all the time. They come up with these amazing innovations and creations. They've put they've put countless hours, blood, sweat, and tears, and they come up with something extremely beautiful, and they don't know how else to protect it. They go and read online about blogs saying that anything that you create technically has a copyright on it, so you're good, and there's nothing else to do. While that's technically accurate, you have a copyright that is automatically attached to your work. In order for you to go and enforce and stop others from using your work, you're going to need to have a copyright registration at a minimum. And sometimes it can be overwhelming because you've created a lot of work and you don't know which one to start with. I always think of it as an asset. This is an asset that you're building into your business. Think of it as a piece of land that you have for that business, and you can feel free to, let anyone who wants to use it for some money or anything like that. It's really an asset that you're creating for your business. So I highly recommend getting a copyright registration for your work. So if you've created a great logo or a very unique design that no one else has out there, go on the copyright.gov, the Copyright Office, and look into registering it. If you have a budget, then work with an attorney because they'll be able to guide you on what kind of intellectual property protection is best for your work. But assuming you're just starting out, there are countless of great blogs and informations and videos on the copyright.gov website that walks you through it. The fee for copyright registrations is $65 for most standard works. And sometimes that can add up. But if you're doing a compilation of work, you can probably look into lumping a few in one application. Or if there is something that is an absolute bestseller and everybody is requesting it, go and get that copyright registration. You might also want to look into other kinds of IP protection, maybe trademark or maybe even a design patent on the work. But if this is for logo or video or audio, look into definitely getting a copyright registration for that. The other thing is if you're selling on third-party platforms, it helps to have that registration or that piece of paper to stop others from using it. And some of the most famous third-party platforms like Etsy or Amazon or Waiver or any of these platforms take these things seriously. Once they see that registration, they automatically stop others from allowing them to sell the work that you've put so much effort and hours and money into. So at a minimum, I would highly recommend going on the copyright.gov website, deciding whether this is a literary element, if your creation is words, training material curriculums. If it is a video, you want to look into visual arts, same thing for the logo. If this is an audio, then you want to look at performance arts to protect that audio and or video as well. But definitely look into that. And if it gets overwhelming and you have too much material and you don't know where to start, think of it from a business point of view, the one piece of content that really brings people through your doors, that resonates with everyone. Start there. And as you continue to grow your business, continue protecting the rest of your work.
So as you can see, regardless of whether or not you're an agency, you're a brand, you're an influencer, you're a third-party creator, there are things that you can do to protect your intellectual property, such as a copyright. There are steps you can take to make sure there's a meeting of the minds between everyone involved as to what steps you can take to protect your intellectual property, like a copyright, and with this common understanding of everyone's rights and what everyone needs to do to move forward to have a successful win-win business transaction. Okay, the 8th document or agreement that I'd like to see more agencies use, more companies use, are called non-disclosure agreements, or NDAs. Google them. I don't need to explain these to you, but basically before you sit down with a client, or if you're a client approaching an agency, before you sit down and share your proprietary, your secret, your confidential information, make sure all parties have executed properly drafted non-disclosure agreement. All right, number 9, waivers of liability, indemnification agreements, and assumption of liability clauses. What these are is, this is a document that basically sets forth who's responsible should something happen. Maybe you're doing a Red Bull type of event. You've got somebody jumping a motorcycle over a pond of alligators and it doesn't work out just the way you wanted it to. If you're the agency creating this marketing campaign, you want to make sure you've delineated in writing who's liable for what and who has waived any and all rights to bring a claim if something goes wrong. Now, the laws are different in each state and in each country when it comes to indemnification agreements, when it comes to waivers, when it comes to assumption of risk. So check with a lawyer in your state when using these types of contracts or agreements. These principles, these theories, these approaches also work when it comes to intellectual property. It also works to the interpretation of a contract clause, whether or not you have the right to use a particular video, a particular actor, a particular platform in a certain way. What happens if you don't? What happens if a client tells you to do something and that client doesn't have the legal right to tell you that, but you relied upon that representation and created content? 6 months later, a year later, litigation happens. Who's responsible? Who reimburses who? Who is responsible for the attorney fees to protect or defend somebody that didn't do anything wrong? This is what waivers of liability, indemnification, and assumption of risk clauses are all about. Think about incorporating these into your agreements. Okay, the last 3 I'm going to go through rather quickly because they're straightforward. It's just that a lot of people don't think about them. Number 10, general crew member agreements. If you have a team, audio, video, setup, right? Whether it's in your studio or if you're traveling to the other side of the country, make sure you've documented your relationship with all the other people involved in a project. Are they employees? Are they independent contractors? Is it their responsibility to have insurance? What about work comp insurance? You see, you want to specify all the details of everyone that's a part of the project that you're working on. Do this to protect yourself as an agency, and do this to help protect your client who's relying on your expertise to create in a professional fashion the content that they've hired you to create. Number 11, cease and desist letters. What happens when somebody uses your intellectual property against your wishes or without your permission, or your client's intellectual property? What happens when you see someone take your website content and duplicate it, or take your video or your audio and use it for their own purposes? You want to have a well-written cease and desist letter, preferably by a good lawyer, on legal letterhead that you can immediately get out to the violating party. Insider tip, don't text it, don't email it over. Make sure you go snail mail. Create your traditional letter on legal letterhead and have it delivered, hand delivered, either by a local sheriff or marshal or police officer, a process server. That'll make the right impact, or maybe FedEx next day mail or UPS next day mail. That's how you get on someone's radar and let them know that you're serious about them violating your rights or your client's rights. And along those same lines, number 12, DMCA takedown notices. When somebody has violated your rights, improperly used your intellectual property on their website, there are steps you can take, and it's called a DMCA notice to put everyone on notice that there's a violation and that you've reasonably requested that that content be taken down. When you combine a DMCA takedown notice with a cease and desist, especially when it comes from a lawyer, I think the chances are pretty strong, especially if it's a matter where everyone's doing business in the same country, here in the United States, for example, where you're going to get the other side's attention and you're going to get them to do what they're legally obligated to do. Now, there are serious consequences when somebody violates your intellectual property. We've talked about that. Pete shared his thoughts. Karima talked a little bit more in detail about copyrights. We see this being a big issue on the digital platforms. Trademark violations happen all the time, and there are serious legal ramifications when you violate someone else's trademark. For that reason, I reached out to a very good friend of mine, Francesca Witzburg, who's an IP lawyer and partner over at Loza & Loza. And I asked Francesca, what happens when somebody violates your trademark? What are the consequences? What are the options? What are the damages? Here's what Francesca told me.
Mitch, that's a great question. Trademarks in the United States are real monetizable, transferable assets. So it's really important at the get-go to do the proper clearance work, make sure that you're not stepping on anyone's toes, to make sure that you actually use your brand before you spend all this time and money creating logos, building out product packaging, and then finding out down the road, whether it be through a cease and desist letter or you finding out some other way, that you do not actually own the name or that there's a problem with the name. So that's really the first step, is making sure that you protect it. But what happens if you do accidentally or maybe willfully use someone else's trademark or one that is confusingly similar? So in the United States, there are various remedies that you can get as an entity or a business owner that has your rights infringed. So the first, like you said, Mitch, is injunctive relief. That's absolutely an option. And what that means to everyone on here, those are preliminary injunctions, permanent injunctions. It means that you can walk into a court and actually ask the court to get the other person who's using a mark that's confusing to stop using. They'll have to pull things off the shelves, pull things down. So that's a very important tool. The other side of that is monetary relief. And so courts could actually issue a trademark owner actual damages, infringers' profits. So how much money did the person using your name or a confusingly similar name profit from by that use? And cost of a lawsuit, attorney's fees. Those are exceptional, though. Those attorney's fees are reserved for cases that are considered exceptional. For example, willful infringement. So this is why it's very important to discuss with a trademark lawyer or an IP lawyer before you decide to pick a name. We can help you avoid expensive litigation, and so that you can focus and businesses can focus on what's important: the creation, the design, the growth, and the sales.
So whether you're an agency using someone's trademark with permission, maybe it's a client's to create content, or you're a client, you're a brand ambassador that for whatever reason is using a trademark, make sure you've got the right to use that trademark. And if you don't, I think Francesca did an excellent job of explaining what your options are. Now, I said at the top of the video, I had 13 agreements and documents that I wanted to talk to you about. There are actually 15 or 20. I've talked about a few other documents that some of my clients have used over the years, documents that we recommend depending on specific circumstances and situations. And if you'd like to know about those particular documents or agreements, jump over to my blog, streaming.lawyer, and use the search bar and search for business documents for online creators, brand ambassadors, and entrepreneurs. I put together a post a few years ago, and it really does lay out some things that I didn't talk about in this short video, and other things that I did talk about that complement what you've already heard in today's video. Now, Let's jump over to contract provisions. 5 provisions that I believe most of you must have in your written agreements. And maybe some of you already do. But before I jump into these 5 provisions, remember, each company, each business is different. The laws and rules and regulations in each state are different. Federal law is different than state law. And what might work here in the United States may not be applicable in the UK or in Australia, for example. So check with a local lawyer when reviewing what documents are right for your agency and what provisions are the right provisions to include in those documents, with those provisions being the following. Number 1, update your force majeure provisions. What's a force majeure provision? Most contracts, most agreements have a force majeure provision. And what this says, if there's a natural disaster, if there's something that's happened, a terrorist attack, that's beyond your control, then the parties to the contract and their responsibility to perform under the terms and conditions of the contract are either paused or terminated. It's a reasonableness clause that protects everyone and everyone's rights in a contract when something happens that's beyond their control. Now, with this crazy, tragic, and devastating upside-down COVID-19 world that we've been living in and coming out of the other side of this world, one of the things that we've done is we've updated our force majeure provisions in our clients' contracts to include situations such as COVID-19 and other viruses or health and safety issues. We have actually beefed up this provision to include the type of situation that we've all been through over the last year. Believe it or not, the courts have split as to whether or not COVID-19 is a force majeure condition. So rather than leave that up to the discretion of a judge or a jury, what we're doing and what we've been doing since March of 2020 is adding into our force majeure provisions language that says COVID-19 and related viruses and health and safety issues like COVID-19 are part of a force majeure provision. And it gives our client the unilateral discretion as to whether or not the client wants to move forward with respect to performing under the terms and conditions of the contract. You need to do the same thing. When you're entering into agreements with your client, if you're entering into agreements with third parties relative to products or services that they're providing to your company, make sure that you have the ability, God forbid that something like this happens again, to legally pause or terminate your obligation to perform under the contract pursuant to a force majeure provision. Give this some thought. It just gives you options. You don't need to execute or assert your force majeure rights, but I like having my clients have this provision, this new updated provision in their contracts to give them the unilateral discretion not to travel to the other side of the country when it's not safe to do so, not to leave their family at home when it's not safe to do so, not be forced to provide services on a crowded, enclosed cruise ship when it's prudent not to do so. That's the power of the new force majeure provision that's been updated to include some of the things that we've talked about. The second of the 5 provisions that I'd like to see in your contracts or agreements is a properly worded work for hire provision. We talked about this earlier. If you're bringing in creators to help you create content for your clients, you want to make sure there's no misunderstanding as to who owns the intellectual property of the content that they're creating. Are they an independent contractor? Are they an employee? If you're the creator being asked by an agency to create a logo, video, an audio podcast, make sure the work for hire agreement that you're using, regardless of which hat you're wearing, the brand, the agency, a creator, an influencer, make sure the rights and remedies are set forth in your work for hire agreement. It'll avoid a lot of misunderstandings. It'll avoid hurt feelings. It'll help protect everyone's rights. And if it's done correctly, it'll help you avoid legal liability and protracted and expensive litigation. The third provision I like to see in all of the contracts that we've talked about are jurisdiction and venue clauses. What these clauses say is that if there's a dispute, if there's a claim, if litigation becomes necessary, then it's agreed to between all the parties that the claim, the litigation, will be adjudicated in the state of, pick your state, the city of, pick your city, and the courthouse located at, pick your courthouse. And so we usually include jurisdiction clauses for our California clients here in California. Any and all legal disputes, claims, or other legal related matters will be adjudicated in Orange County, California. That way, if our clients are doing business with out-of-state companies, Colorado, New York, London, Perth, wherever the client may be around the world, if there's a dispute, it's agreed in writing between all parties that it will be resolved in Orange County, California. This does two things. Number one, it saves our client time and money from having to travel around the world to defend itself. Number two, it reduces the number of frivolous or small claims. Companies not located in California that either have a small dispute or a frivolous claim need to think twice before spending the time or the money to travel across the country or to the other side of the world to protect themselves here in Southern California. Powerful clauses that can go a long ways to keeping your business moving forward in a safe fashion. The fourth provision I like to see in all of our contracts and agreements is an indemnification and waiver provision. What this means is that if you rely upon what someone else gives you, a piece of content, what someone else tells you, yes, I have the legal right to allow you to use this language in this blog post in our advertising campaign. And then you find out later on that they don't have the legal right as represented to you. These provisions allow you to protect yourself should you be involved in a claim and actually force the responsible third party that brought you into this mess in the first place to either defend you, it's their responsibility to hire legal counsel to defend you, or to reimburse you for your reasonable cost and expense with having to retain counsel to defend yourself in court, maybe a mediation or arbitration, or if you have to pay damages, for them to reimburse you for those damages. And indemnification and waiver provision is a powerful tool to help you protect not only you, but your company and your clients. The last provision, provision number 5, I like to see in most of our agreements, is what's called an attorney's fee provision. Once again, each state is different. Check with a lawyer in your state, in your country. But oftentimes, the parties are allowed to contract that if there's a dispute, the losing party has to reimburse the prevailing party for the prevailing party's attorney fees and cost incurred. It's a reasonableness provision that protects you from frivolous lawsuits by the other party. It protects you when somebody, for whatever reason, decides to breach the contract and you have to assert your rights and bring an action against that other party. It gives you the ability to find good, competent, experienced counsel. Maybe it's someone that you normally can't afford to retain, who will look at the contract and look at this provision and have a conversation with you. And they'll look you in the eye and they'll say, listen, normally I wouldn't get involved with this type of breach of contract case, but because you have an attorney's fees clause, because I feel like you have a strong case, because I've looked at the other side and they've got the assets, they're liquid enough to be able to step up if a judge orders them to pay your damages and to pay your attorney's fees under this clause. Yeah, I'm the lawyer that can step in and help you. And so what I've seen with attorney's fee clauses is it allows you as an agency, as a brand ambassador, as an influencer, to find and retain good counsel without being out of pocket and to help you protect your rights under the terms and conditions of the agreement. The other thing it does is it gives you leverage. If the other side knows that there's an attorney's fees clause and they're not standing on strong legal grounds with respect to why they're breaching the contract or why they're failing to perform, they know, or they will know after they speak with independent counsel, that not only are they looking at contractual damages owed to you, but when it's all said and done, they'll also, on top of that, more than likely be ordered by the court to reimburse you for your reasonably incurred attorney's fees, cost, and expenses. It's just a great tool to have that you unilaterally can decide whether or not you want to exercise this clause to help get disputes resolved. We've seen this clause help cases get settled before litigation simply because this clause was within the terms and conditions of the agreements that we talked about. Now, there are a few more tips in addition to these 5 provisions, the 13 different contracts and agreements that I think agencies, brand ambassadors, brands, influencers should all be taking into consideration when doing business, especially doing business online. And I wrote a post once again a few years ago at streaming.lawyer. It's titled 9 Legal, Business, and Entrepreneurial Tips to Help You Start Your Own Online Business. Put that phrase into the search bar and you'll come to the blog post, and it will complement in a little bit more detail some of the things that we've talked about today. That's it. I hope you found today's video helpful. Big shout out to Pete, Francesca, and Karima for taking time from their busy day to share their expertise with all of us. And from me to you, always enjoy the journey and never stop making each day your masterpiece.